One of the claims that's being made by Clair and his sympathizers is that there was a child witness, an eyewitness to the murder, who said that the murderer was, quote, a white man. The eyewitness that they're referring to is 5-year-old Jared. Jared is the son of the Henriksons, one of the kids that Linda Rodgers babysat. It is true that at one point, Jared told police that the assailant was, quote, a white man. But what's overlooked by that simplistic report is that Jared had been all over the map. Jared, again, was a 5-year-old. He's a kindergartner. And his reports, numerous different reports to the police, were internally inconsistent. For instance, he told police first that the person who murdered his, quote, Aunt Linda was the same person that had burglarized the house 1 week before. Jared had apparently witnessed the burglary of the coffee can. And when that report was made back on November 11th, Mr. Henriksen said that his son Jared had seen the burglar steal the coffee can, and Mr. Henriksen said Jared could not describe the person. No further description was given. When Jared was first contacted by police on the night of the murder, he said the person was the same person who had done the burglary 1 week earlier. Then Jared said that the person who had done it was, quote, a white man. Then he told police that it was a, quote, black man. Then his next version of events was that it was both a white man and a black man. His next version of events was that it was a white man and a black man and a white woman. And then finally Jared said it was a white man and a black man and a white woman and a black woman. So these things can't all be true. And then what's more, about a month later, Mrs. Henriksen called police to say that her son, Jared, had seen in the newspaper that very morning a picture of Kenneth Clair and had pointed to it without any prompting and said, that's the man that killed Aunt Linda. So that's the entire context of Jared's report of having been an eyewitness. It's not a simple case of a person saying it was a white man who did it. All of this was known. This was all turned over to the defense, and they had ample opportunity to make whatever use they would make of that evidence. Ultimately, at trial, the defense decided that they would not call Jared because Jared is a 5-year-old boy.
In fact, there's a fair chance that under the California Evidence Code,
It's unlikely Jared would have been qualified as a competent witness and allowed to give testimony, precisely because he's a kindergartner and doesn't seem to be able to give competent, reliable evidence as is required in order for a person to testify. What's more, we've had a federal district court who's reviewed this and found that the child witnesses, such as Jared, were inconsistent, inherently unbelievable, unreliable, and so it was perfectly understandable for the defense to not call these witnesses at trial. Moreover, if they had, just to elicit the single fact that at one time he said it was, quote, a white man, well, what would happen on cross-examination is the district attorney would then bring into evidence all the inconsistent statements of Jared, which would include that it was a black man and that women were involved, and even more dangerously still, that he had pointed to a picture of Kenneth Clair and said, that's the man that killed Aunt Linda. Why would the defense want to put an eyewitness on during an identification case? Additionally, the defense and the prosecution had entered into a stipulation prior to trial. The defense, knowing that there was risk involved in putting the witness on, the child witness on, nevertheless was able to obtain from the district attorney a concession that if they didn't call the child witness, in return, the DA would make no mention to the jury of the fact that there were kids present at home at the time of the murder. That's a very aggravating fact. And that's a fact that could have been argued to the jury at the time of penalty phase as a reason supporting giving the death penalty. What a cold and remorseless thing to do, to kill a woman, in fact, the mother of one of the children who was present, in the very presence, or at least in the same home as the kids were. And so all the reviewing courts have said that's a very sound tactical decision of the defense. Not much upside to calling the kid witnesses, and in exchange for not calling them, they obtained the benefit of not having the jury hear this aggravating evidence.